Hi, everybody. I'm immigration lawyer John Khosravi. Thank you for joining us for the regular show we have every Tuesday, 5 p.m. Pacific time, 8 p.m. Eastern time. It's a special edition. We're going a whole hour today, live on YouTube, LinkedIn, and Facebook, and Instagram, and TikTok. We're having a wonderful associate, Anya Sergeyeva. Those on TikTok won't be able to see her. Hopefully, you can hear her and what we're talking about. We're taking your questions live. We're going to probably spend more time answering the questions that typically for an hour. And instead of the regular three video consultation free that we give 5 for month. All you gotta do is subscribe, ask a question, and write the word consultation at the end of it. We know you want to participate. No random people to get involved. So I'm echoing if you could turn down the volume on
I hear you well, John. I hear you very well on Instagram, so I don't have any echoes here, nothing. So
yeah, I turned down the volume on everything else, and so just have Instagram volume only to avoid the echo. That may solve the issue for everyone. Just turn the volume down on everything. So that's the best way to deal with that. I don't know. I think if Anya, let's turn the volume down on Instagram and just use that StreamYard, and that might be the best way to do it. Let me turn my volume on here.
Yes. Sorry, guys.
So we'll figure this out. We should have tested this one out, but the only way you go live is like this.
Okay, is it better now?
Hey, are people hearing echo still? Okay, might be better. I don't hear the echo that was there. But let's jump into it. It's better now. Let's do it. We have a question. Daryl Winnebaugh, one of our regulars, good to see you. Says good evening and Merry Christmas. Merry Christmas to you too. So let's start the show officially. So as we said, we're giving away 5 free video consultations today. You got to just ask a good question and write consultation at the end of it, and we'll randomly choose 5 people for the hour. My associate attorney, Anya Sergeyeva, on. She's wonderful. She's over on the East Coast. I handle the West Coast, but we take over and handle cases all across the country. It's been a wild year, this 2022, a lot of ups and downs, and we pray that 2023 is going to be much better. A lot of people from Afghanistan to Ukraine, all across the world and at the border, are dealing with really tragic issues with regards to immigration. On the other side, there's people that are going through the process and are dealing with unexpected delays, taking years for maybe to bring their spouse to the United States or their kids. So we really have our heartfelt out, and our prayer at this Christmas and this New Year's and this season is that better things will come about in 2022. And we'll do our best in the show to try to answer some questions, alleviate some of these issues. So let's jump into it. We got the show started. A lot of people saying nice stuff. John, you're good. Hey, Merry Christmas. Such occasion, be good to you too. I think we got some questions that popped up on TikTok, so those will be coming in on a sec. But I'll start with Instagram. Happy Patel asks, I applied for the I-485 almost 19 months ago. How long does it take? How long more time does it take? Now, we got a lot of the same questions coming on, but we don't usually talk about a lot of the timeline questions just because there's no answer to these, but people heard me say it a lot of time. Anya, why don't you talk about your thoughts on these timelines and if it's even possible to answer this particular kind of question?
Well, thank you, John. It's really hard to tell how much time it's going to take, particularly in your case. Some cases take more time. Some cases take less time. It would depends on what category are you applying under. It's gonna depend on your local office. It's also gonna depend on whether USCIS decides to waive an interview in your case. Like recently, we've been seeing a lot of our cases getting approved. I'm talking about I-485 adjustment of status cases. They're getting approved without the interview, and I think John, you're gonna talk about this a little more, right? So, and really, there is no like right or wrong answer here, because again, your case is your case and no one else has a case like yours. And if your brother or your neighbor's friend or something like that, they applied at the same time with you, they got approved and your case is not getting approved. It's not necessarily that something is wrong with your case. It's just what it takes, so 19 months, I would say it's more than usual, probably. But again, depending on your local office, maybe it's okay.
Yeah. Now, one thing we are seeing a lot now is, and just every week we're getting it, is these interview waivers, which is a godsend. So We have cases where we submit it and they just approve the I-130 for a marriage case, for example, prove relationship is real, and then just send us a RFE, request for evidence, for the medical checkup, which is some cases surprising because we expected it from couples who have kids together, have been married for 20 years, so it's easy for them to approve that. But we're getting it for more recently married couples that are just fresh marriages and stuff. We always submit the I-130 petition. When we start a marriage green card case at our firm, some firms have a policy of just sending the forms, that's it, and then having you bring the evidence of your relationship to the interview. Our policy has always been, get as much evidence at the beginning, do all the work when you start, so that USCIS automatically understands that this relationship is real. And when you go to the interview, it's a cakewalk. It's just procedural. And that has served us well because we're getting all these waivers without them asking for more evidence of the relationship. They just want the medical checkup and they're proving green cards. It's a Christmas miracle. So let's put it that way. So we've been really happy about how that's going. So with regard to timeline, as Anya said, 19 months is it's out of control. 19 months is kind of crazy, but it's not unheard of. And it just depends on your local office, your case. You got to keep an eye on it. Maybe they sent your request for evidence. You didn't get it. That happens sometimes. It goes to an old address. And in fact, you might have denied your case. Not to scare you, but there's a lot of different things that happen when cases go long. You got to keep an eye on it, check on it. And we haven't seen your original application package. So I don't know if there are errors on there that's problematic or confusion. And we don't know your history for your case. So it's hard to really give advice. But in general, timelines, it's just every case is different. There's no real good, honest way to give an answer to that. So we have a question. The next one for user 711 is about prosecutorial discretion. They have a master hearing and want to add and close the case. Our office does not do removal proceedings or deportation hearings. But for prosecutorial discretion, the government has put aside a list of things that they take into consideration about your background and the type of case you have. For example, if you have a form of relief, if you have a form getting a green card if you're out of immigration court, then that's a serious thing they'll look at. And your good bona fides and how good a person you're, all this kind of stuff, and the risks of going back to your home country, what will happen. But it's not our specialty. We don't do removal proceedings. You definitely need to have a lawyer with you at your master hearing. That's the first hearing that you have in an immigration court case, and work with them to develop a good case, to talk with the ICE attorney to get a win on that. But thank you for your question. So Anya, you want to read this one?
Yes. So Abu is asking, hi, I was a DV 2021 winner, but my interview was not scheduled because of coronavirus. Time has passed. So now I'm applying for F1 visa. Should I write on DS-160 form that I was a DV winner and DS-260? So do you want me to answer this question?
What's that?
Do you want me to answer this question?
Sure. Go ahead. What's your opinion?
Well, generally, yes, if you filed, so there are two steps of the process when we are talking about the DV lottery. Okay, first step of the process is just when you applying for the lottery, when you're submitting your initial registration. Okay, and out of like millions of people who submit, only less than 1% actually win. Okay, and out of these people who won, less people are even proceeding further with their application. And what I'm talking about is proceeding further. This is step 2. This is submitting DS-260 if you are overseas, okay, and filing for adjustment of status if you are here in the United States in lawful status, okay. So, and if you just like submitting your registration, for green card lottery and you didn't win, you never won, this does not consider to be like immigrant intent that you're gonna come to the United States and and live here, because again, only less than 1% of people actually get to that point. Okay, but once you submit your DS-260, that's when you show in U.S. government, yes, I want to pursue further. Okay, I want to immigrate. So if you submitted your DS-260, yes, you have to be truthful and you have to provide this information in any further applications. Okay. So again, it's going to be up to them whether they approve it or not, but no line to U.S. government, because this is something that they will never forgive. Okay. So you just have to be truthful, and good luck.
Yeah, you haven't have you had a petition, so that's kind of different, and you haven't had your interview, so you didn't have a direct denial. But it's just better to tell them on the record, so they see the documents are there. So on the place on DS-160 that talks about previous petition or something like that, just mention it. That by itself is probably not gonna be a problem. getting F1 visa approved on its own is another thing. So that's that. But thank you for your question.
Thank you, Abu.
All right. So next question, Noof. I think Noof was a contact for a while. Says, I'm a visitor visa. He has a visitor visa. He stayed 6 months. Can he leave the country for a week and then come back immediately? We get this question a lot. And the reality is, when you get a tourist visa for the United States, when you enter the United States, typically they give you 6 months of time to be here. Sometimes they decrease it. On some extraordinary circumstances, you could potentially ask them to get a year's worth of stay instead of 6 months. But what happens? You're here for a whole 6 months. You use it to the maximum when you leave. Can you just turn around and come back on you?
Well, again, visa does not guarantee that you're gonna be able to come back to the United States. Visa, I'm talking about the visa stamp on your passport. Okay, what it allows you, it allows you to sit on the plane. Okay, get to the United States soil, or like walk through the bridge or something. If we're talking about like Canada or Mexico, right, and present yourself to U.S. government official, to CBP, Customs and Border Protection Officer, and it's going to be up to them whether admit you to the United States or deny your entry, and it's going to be up to them for how long they're going to admit you, and they will look into. Okay, this is a tourist visa. So when we're talking about that, they ask you, okay, you were here for 6 months. What were you doing? Are you working? Are you not working? And it's all comes into play because they want to make sure that you actually satisfy the purposes of your tourist visa. Tourist visa is for someone to come here to the United States, go to Disneyland, go here, go to Las Vegas, and just have fun and go back to your home country, and continue with like your work, your life there, etc. If you're living here under the tourist visa, this is a problem because
and you could lead to a ban if they think that you're working here. Because like, how are you making money? How do you afford just continuously be in the U.S.? Now I've seen people do it, especially Canadians come and go a lot, but eventually it catch up with you. So I mean, just why do you need to be here in the U.S. so long? It gets kind of problematic. Now, one quick note I want to make is, if you have a question, please just post it once. If you keep repeatedly posting it, we'll have to remove you from the channel. It's because very confusing. We have so many questions coming in, and if you try to crowd out other people, it's not fair. So we will kick you out of channel. So for example, Adnan, please asking the same thing over again. I understand it's very important for you, but you only ask once. As you keep asking again, we're going to ban people if they keep asking the same question over again, which is happening.
Yeah, I see messages here on Instagram that someone is saying it's worse on Instagram now. Sorry, guys. We're trying to fix it. Yeah.
My bad. Good. We'll try to get it to fix out. So we'll take the next question. Paranoid Andrew, when a regular citizen, since an H and an L visa and O are dual intent, well, O is not dual intent visa. How long must an H and L visa holder wait after entering work in the U.S. before self-petitioning? Is there a cooling off period? So, the immigration laws are set in a way that if you enter the United States with a non-immigrant visa is temporary, which includes work visas, you're not allowed to come in with the actual intent of staying in the U.S. permanently. If you do that, that becomes a potential violation for fraud. Now, they made an exception for H work visas and L visas, and you could come into the United States with the intent to file for green card and still get the green card. It's not an issue because they're dual intents written in the statute. So there's no cooling off period for those. I have seen the government make errors on that and have problems, but practically speaking, you could do whatever you like because you're allowed to have immigrant intent on those. O visas are not dual intent. They're a quasi-dual intent in that sometimes they'll approve an O extension if you have a green card case pending, or if you have an I-1, more likely, if you have an I-140 approved or pending, they may still issue the O visa. So it's a soft dual intent. It's not by statute. So you can't come into the United States with an O visa and then turn around and immediately apply for adjustment of status. That's going to be a potential fraud finding. So you got to be very careful of that. All right, so we'll get the next question. One safe to ask, can you explain the process of vaccine exception during K-1 visa, how it plays in the adjustment of status? So in general, there's a requirement for getting the COVID vaccine or other vaccines for getting a green card for the United States. If you want to do an exemption, you have to make a special request for that. We don't really do that too often at all, but you got to have a reason for it. Anya, you might want to talk a little bit about that shortly, about what kind of stuff they look at.
Well, yeah, when we're talking about K-1 visa, if we're not talking about COVID vaccine, because COVID vaccine, this is something that is required. And again, and unless you get an exemption, you'll not even be able to sit on the plane and, come to the United States, right? But generally, when you overseas and is about to get your K1 fiance visa at the embassy or U.S. consulate. Okay, what you need to do before that, you need to have an medical exam appointment with the doctor in your home country, and they want to make sure that you satisfy all the requirements. Okay, and sometimes from what we see, some K1 applicants, they have this option, not to do all the vaccines overseas, but come to the United States and do them later. Okay, but again, this is not applicable to COVID vaccine. Okay, so this is one thing that we can talk about, and what John covered. Yes, if generally you're opposed to vaccines, there is a procedure of requesting a waiver, based on moral or religious obligations, and there are a few other grounds to get this waiver. It would depend on like your health condition. It takes a doctor can take this into consideration too, but it's a huge big topic. If I start talking about this, there's like blanket exemption or this waiver exemption or like something else. Is it possible? Yes, it's possible. In some situations, just the doctor can do the exemption, again when it's like medically appropriate or medically inappropriate or something like that. And for example, if you're asking for religious exemption, or it has to be done through USCIS.
Yeah.
So.
Oh, thank you. Now, one note, we might shut down the Instagram account. I think the feedback is so much, it might be frustrating people. So, might just sorry everyone on Instagram. Tune in on the YouTube channel, on TikTok, on Facebook, and LinkedIn. We're everywhere. But there's so much feedback going on. It's probably gonna be frustrating for people to hear this. The voice coming. So we'll have to figure this out next time we do this for Instagram. Maybe do a standalone for Instagram.
Guys,
everybody on Instagram.
We're still gonna be there.
Bye. All right, so we'll shut that down. And video. All right, thank you for everyone. Stay tuned. Just the live shows, this is what happens. So let's take the next question. Special occasion: does the N400 after mayor's 3-year decision have a bias for people who do not work but live on sponsor funds? Is it better file to finding a job? So it's a question we get a lot, because there's a question on the citizenship application about work history. And people get very paranoid if they haven't worked or if they got unemployment benefits. The quick answer to that is no, none of that matters. They don't judge you based on that. The focus of citizenship is to make sure you don't have any criminal history, you don't have any bad history in regards to false claim to U.S. citizenship, being a part of a military group that's like, guess, the United States or something like that. You haven't had too many absences from the U.S. You've always filed your taxes. You didn't get your green card by mistake. They don't get into work, other than maybe if you work for like a marijuana dispensary, that's an issue because that's illegal for federal law. But not having work and stuff, that has no problem. So that's not something we worry about.
Yes, this is a great question, for moms. For example, I'm a mom myself, and I stayed with my kids at home when I was going through the immigration process, and I was worried about the same issue too, But again, as John mentioned, there's nothing wrong with it, and sometimes even you can put unemployed, slash homemaker,
Mm-hmm.
Yeah. You're taking care of your kids. You're taking care of the house of your spouse, and there's nothing wrong with it.
Wonderful. And you know what? Special occasion, you're our winner for our first free consultation giveaway. Just take a screenshot of where you're watching this and email it to me at info@jqqlaw.com, and we'll schedule a private consultation. Again, that's info@jqqlaw.com. For those just tuning in, we give away free video consultations. We got 4 more to give away. All you got to do is like and subscribe and have a question and write consultation at the end of it, and we'll randomly choose people for this free video consultation, talk in private. There's a lot of stuff here it's too public we can't discuss necessarily on an individual basis. It's all general educational stuff here. Miranda asks, I have an I-751 pending, and we are applying for the N400. What additional evidence do you recommend? So I don't know your individual case, so I can't tell you what the evidence you need. But the basics for an N400, your green card front and back, marriage certificate, any divorce certificates. If you have criminal history, you got to deal with that. So it's just the basics. But again, Miranda, other than your first name,
U.S. passport too for this specific rule. If you file it under the 3-year rule.
Yeah, and evidence that you're living together for the last 3 years. It can be lease agreements, property agreements, taxes and stuff like that. Driver's license, same address, all that kind of stuff is helpful. But again, I can't recommend anything to you because I don't know anything about your case, Miranda. But I wish you the best. I-751 cases are pending a long time. So it is a good trick for most cases to file the citizenship case to get it up and running. So Jordan, one of our regulars. Hey, John, Merry Christmas to you too. Is it possible to extend an M1 visa work permit beyond 6 months after vocational training? Now, I haven't dealt with M1 for a while, as you know, but I don't think you can extend it. M1s are like there's a limitation on them. So I doubt you can. But having said that, it's not something we deal with or have done recently. So I'd have to look up something like that. But from what I recall, when 5 years ago I dealt with an M1, I don't think that's possible. I can't say for sure. Next question is, how hard is it to get an EB1? So, it's questions that possible to answer because, hey, if you won a gold medal for swimming in the Olympics, it's very easy. If you won 2 awards when you were 15, it's very hard to impossible. So when you ask a general question on that, is like, it's impossible to answer that question. It really depends on your own case.
Yeah, the standard is high. The standard is high, right?
Yeah.
But a lot of people are able to get it. So you have to talk to attorney to see if you qualify under this category. And good luck.
Definitely. So we have a lot of questions. So sorry, you got to be patient. Hopefully we get to all yours, but we were just getting innovative.
We have 1 hour today, so.
Yeah, we're here for an hour, so it'll be a little bit longer. On TikTok, the voice you're hearing is my associate attorney. We couldn't do dual, so you're just seeing me. Hopefully you could hear her, but just got to be patient. There's just a lot of questions. LinkedIn user asked your thoughts and suggestions on how to change that. Processing time seems to be random and dependent on the DOL USS processing times, but is there some way always to change that? It's a political situation to change this stuff, really. And the politics are always against immigration from both parties. So not really. On an individual level, lawsuits are the way to go. When you sue them, a lot of times they get really fast. So if you want changes, just sue a lot. And the more people who sue, the more the court system sees this, the more public it becomes how ridiculous the timelines are, the more chances the government's just going to act because they get frustrated from being sued so much. So lawsuits are the way to go. But, there's a cost of that. Sheila Doe asks, please, is it possible to revoke and approve I-130 and why? I need to take that one. We've seen our share of these people come to us with this problem.
Well, revoking I-130, I don't know, maybe John, you're going to answer that.
Well, yes, they can always revoke this stuff, and it does happen. Initially they approve it, and then they do more research later, and they realize, oh, we approved it in error, and maybe there was fraud going on, or maybe they don't believe you. So a revocation of the I-130 is possible. If you got the green card, a rescission of it is possible. If it's within 5 years, and after 5 years, they can still take it all away and to send your deportation rule proceedings to take it away. So the thing about immigration is whatever you have, it's not guaranteed to stay with you. And that's one of the reasons you want to file for citizenship as soon as possible. And more importantly, you want to have a good lawyer work with you to make sure you have a solid case. So for example, the way we see a lot of these revocations of I-130s is we have a client who comes to us. Usually, this is after the fact where they come to us. But for example, you're married, you start a green card case, you submit Form I-130, and then while the case is pending, your relationship falls apart, you get divorced, and the case just goes away. 10, 15 years later, you're still in the United States, you get remarried to a U.S. citizen, you file for a green card. And that green card gets approved, and then they realize, oh, you're married before, and they don't believe that initial marriage was real that you filed a petition on, and because of that, they can accuse you of fraud and revoke the approved I-130 on the second marriage. It's very nasty because you have to prove that first relationship was real, but you may not have documents from 2005, 2010 anymore. You may hate your former spouse and you ripped up all the photos together and the stuff because you don't want to have any memories of them. And then what happens? You have no evidence to prove that the initial marriage is real because you got to prove both marriages now. So those kind of stuff happen. It's very nasty. It's very hard to deal with, but it is something that pops up.
Yeah, and I just want to add to it. Once we often see too, it's not part of the revocation, but it's right there, right close to it. For example, when you have your I-130 approved for consular processing, a National Visa Center opens up your case and you don't act on it within 1 year. You don't do anything. Your beneficiary does not apply for a visa. That's it. They're gonna revoke it, not revoke it. I think they just destroy this I-130 petition, and it's not going anywhere. And after that, it's almost impossible to bring it back to life. So.
Yeah, you got to fight and restart. It's a mess. So you just got to keep an eye out on this to make sure stuff doesn't happen. A special occasion, we're going to have a private chat about this, so we're going to skip that. U.S. Quran asks, in dashboard says document delivery information. What does this mean while waiting for a visa? I don't know which dashboard you're looking at, so I'm sorry. I don't have an answer. Do you have an idea what they're talking about, Anya?
Well, probably when you go to your like online cabinet once you apply for the visa and you schedule delivery, I assume it's might be about that something. You know, when your passport gets delivered to where you ask them to for it to be delivered. You know.
On the visa, U.S. visa info site or something like that. Yeah, so we have to see what exactly it is, but you know, if it says document delivery information, put the information you need for delivery. That's about it. Shaki asks, if the dad of a U.S. citizen is 85 years old and needs medical care, would he qualify for a green card? You know, it's possible. I've had cases like this. They got more stricter, but I had a a sad case where we got the green card for the 85-year-old dad, and about a month and a half late after he arrived, he passed away. So his whole family was here. I was really kind of lucky that he spent the last days he had with his family. But you know, there's a rule called the public charge rule that says, is this person going to cost U.S. taxpayers once they come to the United States? Now, if a U.S. citizen is applying for their father, they submit what's called an affidavit of support form I-864, and that to show they have enough money to support the father, and they can maybe get insurance for them, all this kind of stuff. So it doesn't necessarily mean the case will be denied, and frequently it is approved, but you have to have a good affidavit of support. If they push back, you can show you have money. But historically, they've been pretty forgiving and open about this. So it's not like a thing I would say worry about, but you got to have a good affidavit of support.
And plus, like USAS, U.S. government, you cannot discriminate people because of their age or something. So it goes to that too.
Yeah. I mean, they'll look at the whole thing for public charge, but historically, public charge has not been a real issue.
Yeah, and there's new public charge rule, by the way, in force starting December 23rd. New I-485 form. And please, all of you guys who is about to apply, make sure that you are using the most recent edition. Okay, you answer all the public charge questions. We have a very good video that we did live with John. I think it was last week. So please check it out on our YouTube channel. You'll find probably most of your answers will be there, but I'm sure not everything, but just go there. This should be your first source of information.
In this case, if the parent is overseas, they haven't updated the paperwork for the embassy on this, which will come soon. So that's there. But my sister Katrina Shabikhan has named you as our winner of our free consultation raffle. So take a screenshot where you're watching this, so your username is there. We know it's you. Email it to me at info@jqqlaw.com. We'll have a free 15-minute video chat to talk about your case. For those just tuning into the live show, we give away free video consultations. All you gotta do is like and subscribe, and ask me a question, right? Consultation at the end of it, and we'll give away three more consultations. Sorry, my throat's starting to give way from 30 minutes, so I know it's gonna take more. Anya, why don't you go over to the next one?
You have tea. I don't have tea, so you have more stamina here. All right. Let's take another question. One saved, always saved. Can you explain how to go about denying vaccines for religious reasons at the medical exam and applying for a waiver in the K-1 process? What does this process look like and tie to the adjustment of status? Okay, John, do you wanna answer that one?
Yeah, I mean, how to deny it? You're denied if you don't satisfy the vaccine requirement or get a waiver approved. They're just gonna deny it, and your case is denied. That's about it. So you just got to get the vaccine. I mean, I hate to say that, but it's very hard to do it. If you have really good religious documentation, it's not just the COVID vaccine, for example. You don't get any of the vaccines, or you're a member of a church your church verifies you go there and that church doesn't believe in vaccines or something like that. Maybe you can pull it off, but it's going to increase a lot of time on your case. It's not clear if it's going to get approved or not. So typically, you just tell people get it and get it done with it.
All right. Next question we have. Moy asks, can a permanent resident petition a future spouse from Mexico? Well, this is a good one. I can answer that one.
Sure.
So if you're a permanent resident, you don't have option to apply for a fiance visa. Okay. So only one option for you to bring your spouse here to the United States is to get married. And after you guys get married, your spouse qualify, and you can file a 130 petition for alien relative and bring them here to the United States.
Yeah, that's it. So we're getting into our second half hour. It's a special edition. We're going to go much longer, and as it would be, we have so many questions left. So sorry if we're not getting to your questions. It just takes a while. We have a long list. But Anya, why don't you start reading out the questions, and I'll help the answer, so it gives me a break.
All right, Musa, how can I bring my underage sister to the United States with my mom without my mom have to come to the United States to petition her?
So, it's going to be hard to do that because from you can't, if you petition your sister, it's take 20 years. So typically you petition for your mom and the mom petitions. There's this way maybe you could apply for humanitarian parole for your sister to be paroled into the United States. And then once she's here, apply. It's a long shot, and there's a million reasons why they could deny it. That might be something. But overall, yeah, usually we have them do a petition in that way that you're talking about. Adoption won't work because, adoption is not something you typically handle. If you're thinking about like you adopting them, adoption does have to happen before a child's 16, but a lot of times in many countries, both parents have to have been deceased for you to be able to adopt it. And so it depends on how the adoption rules are. It's just a whole complex kind of thing. Maybe it's possible. It's a very long shot as well.
Yeah, but the best, this is one of the immigration strategies we utilize often for like minor siblings of US citizens. Again, as John mentioned, if you directly apply for your sibling, it's going to take 15, 20 years. God knows how much time it's going to take. But again, you always, if you're a US citizen, again, you have the option to apply for your parents, okay? For one parent to begin with, you're applying for one parent. This one parent comes to the United States. Then once they're here, they apply for a second parent, and your minor siblings, they come together with the second parent, because this is that's how things work.
Yeah.
In this category. Yeah.
So next question, Adnan's been asking this question 30 times. So I have some good news for you. Adnan says, I'm eligible for a green card if I was evacuated along with my citizen spouse on humanitarian parole. And the answer is probably yes. I say probably because I don't know enough about your background. But to apply for adjustment of status, a green card in the United States, you have to have lawful entry, which you do have on parole. And you're married to a U.S. citizen, so that's the basis of adjustment. So we need to know more about your background. There could be different reasons they could deny it based on your associations and after support, this and that. But yes, it's possible. Just got to get into it and fill out all the paperwork for it, and honestly do a review first to see if there's any inadmissibility issues. But there's a good chance you get your green card. We have the case like this, Afghan evacuee last year, so it's definitely possible. If you are from Afghanistan, look into TPS if it's not too late as well, something to get as a backup. So Nick asked, yeah, go ahead.
Yeah, Nick is asking, is claiming to be a green card holder and using fake green card on I-9 punishable the same way as claiming to be a U.S. citizen?
So it's not punishable the same way, because if you also claim to be a U.S. citizen, then they're going to deport you. That's really hardcore. They won't necessarily deport you if you do fraud on using a fake green card. And historically, they've been pretty easygoing about it. But depending on the state, it could be accused of using false documents, which could be a serious crime in the state that you're in. And that criminal activity can lead you to be deported. There was one case, I think, out of Utah, where a guy used a fake ID, and they charged him and put him in jail for that. And that was the basis of him being deported. It went all the way to Supreme Court, and they still kicked him out. So typically, they're pretty easygoing about this, but if they want to, they get hardcore about it, especially if you've been charged and arrested for something like this. So it's not exactly the same way as a citizenship. It may be a waiver possible. It depends on how the statute's written. It gets complicated. It goes into immigration. But the basic question you're asking is it dealt with the same way as U.S. citizenship, false claim to U.S. citizenship? No.
Thank you, John. All right. So Delaware asks, can I appeal the denied decision on I-130, I guess, I-131 travel application?
So I can't remember if you can appeal that. You have to have a good reason, but honestly, the denial notice will have it on there. We never get denials on this, so the issue doesn't really pop up because usually travel documents are always approved. I'm not sure why they would have denied yours, but you got to see. I think they give you some time on their list on there. It depends on what the basis of the denial is. If you're never entitled to the document in the first place, no. But I haven't dealt with denial, so it's not something I'd have to go research. I don't know off the top of my head.
Yeah, and when we talk about denial, like any kind of denial, again, depends on what kind of application we're talking about. But sometimes it's better just to reapply, rather than to appeal, because appeal can take more time and more money and everything. And sometimes you can reapply. So maybe it's something to look into in this situation.
Yeah, for sure.
All right. I need to renew my marriage-based green card. So if I apply for renewal, they do interview or not? So I can answer this one. Yeah. So here we're talking about I-751 removal of condition, I think, right? Most likely, right. Because there are two ways how you can renew your green card. One is like renewal when we're talking about if you already have your 10-year green card and it's expiring and you just file for renewal. This is like typical renewal, okay? And if you have 2-year green card and you got your green card based on marriage to a citizen or a green card holder, okay, after 2 years, 90 days before the expiration, you have to file for removal. And 2 forms are different, and we often see when people file the different form for renewal that I talked at the beginning. For 10 years they file for instead of I-751, and it's really get messed up. But going back to your question, will they gonna do an interview if you filed for I-751? Maybe they will, maybe they will not. Okay, if we're talking about I-90, most likely there will be no interview. They're going to send you just renewal by mail. But again, if this is I-751 case, removal of conditions, and we're talking about 2-year marriage green card, there is new interview waiver policy regarding I-751 applications. And some of these cases, they qualify for interview waiver. But again, in our practice, what we see most often is that because these cases processing times are like skyrocketing. So what we do for our clients, we're oftentimes, once the time comes to apply for naturalization, we apply for naturalization. And this a little bit, in some cases, again, this can speed up the I-751 process. And what USCIS does, they just combine the interview, I-751 interview and naturalization N-400 interview. Okay, and at this interview, I'm talking about I-751, a spouse has to be present, and there is no way that they're gonna waive it. There is no waiver for N-400. So that's what it is. I hope I answered your question. Thank you. Okay. Silai, my brother is a neurosurgeon. He wants to come to the United States to study. Is there any scholarship program or something? I wish Owais was here. We have our colleague Owais Kazi. He deals with he actually now has like a few neurosurgeon petitions, so he would be in the best position probably to answer that. Do you want to cover it, John?
I mean, with regard to scholarships, that's up to the school. So you need to contact them. It depends on your grades. If you're a great student, they may have that. So it really goes outside of immigration law. But if he's a great neurosurgeon, maybe he could file for a green card or O1 visa. We're handling those right now at our firm. But your specific question, depends on the school. So you got to contact them and see what
maybe again, your brother can look into EB1 category, EB2 national interest waiver, or O1 visa. So it really depends on his credentials and where he stands in his field.
Yeah, and try to go for the immigration route, not just the student visa. Yeah. All right. Savage asks, when do you feel the visa bulletin may move? It's not about how we feel. It's a secretive process where they calculate this stuff. So we just go with what they give us, really.
Yeah, and depends on what category we're talking about here. Some categories they move, some categories they don't move, like F4. Right, John? We checked last time. I don't remember, but it hasn't been moving.
Yeah. F3 and F4 are not moving at all. So these are adult children or green card holders or citizens or married and brother and sister of U.S. citizens. Not moving at all. Very frustrating. Many clients contacted us. Why aren't they scheduling an interview? I'm like, because the line isn't moving for some reason. So that's something, I don't know who to sue upon. They make sure they should sue and say, they're not being transparent of how they calculate this stuff because it doesn't make sense. And maybe that'll lead us to get some more information on what exactly is going on. Go ahead, you read the question.
Okay, sticky one. Is it faster to process your green card via adjustment of status or consular at the embassy?
So, there's no answer to that one. For example, you may do adjustment of status. It takes 3 months to get approved one day, and then it takes 2 years another day. Or you're doing embassy processing, and you might be in India or Pakistan where it takes 2 years to get an interview. Or you might be in Germany where it'll take like 3-4 months to get an interview. So it depends on if you're doing consular processing, which embassy you're dealing with. But if you're in the U.S., it depends on which field office, which officer gets it. Having said that, an embassy like Germany may get the interview faster, but you still need to get an I-130 approved first. And I-130s are taking much longer. So the consular processing portion may be fast, but the initial petition may take longer. Whereas if you did the initial petition in the U.S. with adjustment of status, it might get done the same amount of time. So it's kind of, there's no real answer to this one. It's just, you got to do whatever the law allows you to do and whatever works in your personal life. A lot of times people want to game the system, go faster than that. A lot of times you can't do that. You just got to see which benefits, your career and your life and to file for adjustment of status, you have to have lawful admission without the immigrant intent. If that could be a problem too. So there's a lot of different factors to look at when you make the decision, other than which is fastest. Although I know if you want to get the green card, get done with this faster, it's not the best way to look at it, just from experience. There's a lot of other factors.
Thank you, John. Yeah, I just want to add to that. You always have to think what category I applying under. For example, if we're talking about DV lottery, for DV lottery, preferable way. Again, if you are in the United States and lawful status, you are maintaining your status. It's always file for adjustment of status rather than processing through the embassy, because again, as we see, some people they just never get called for an interview under this category.
Mm-hmm.
So, and again, when we're talking about adjustment of status, don't forget that you'll not have work permit unless you file for expedite right away. You'll not be able to travel for some time until your green card application gets approved. So there are both pros and cons in both of these options, and you just have to figure out what's more important for you in your particular situation. But they both workable.
Definitely. Thank you, Anya.
Okay. Natalie, my boyfriend and I are wanting to get married soon. We won't be sharing bank accounts, living together when we apply for the visa. Will this be a determinant on proving the validity of our relationship? We get this question often too from our clients, and the answer that I give to clients always is that you don't have to, match your life to immigration. If this is your decision not to have like joint bank account, this is fine. A lot of people, they don't want to do that. Yes, USCIS prefer you to have that, right? But if you don't want to do it, you don't have to do it. Okay. Living together is more, I would say, problematic, but we have had cases approved where spouses are not living together, as long as there is, like logic reason behind it. Why you don't want to live together? Are you like studying in one state and your spouse is working in a different state, and you just cannot live together because of this reasons, and that's been fine, so it's really depend on your particular situation and what USCIS will do. They will look at everything together. They will not just look at one thing. Oh, they don't have joint accounts together, so let's deny this case. Thank God it doesn't work like that. So
if you've been dating and you have a relationship, you're gonna have other documents you bring in. Our job when we do these cases is to dig in and see what other evidence of your relationship we could put. Might be letters from family and friends and a lot of other things. So you just gotta have a good case, and this is where it becomes important to have an attorney. Actually, Katrina, our assistant, wonderful assistant, said that you are a winner for a raffle. So we can have a quick chat about this. Just take a screenshot wherever you're watching this, so we can see your username, that is you, and email it to me at info@jqqlaw.com. And we can schedule a quick chat, talk about this, see what's going on with your case, and hopefully they'll help you out in private. But thanks. So for those just tuning in a live show, we give away free video consultations. We have 2 or 3 left. I think I have 2 of them left. All you gotta do is like and subscribe and ask a good question, write consultation at the end, and we'll name a winner to have a free private consultation to discuss this stuff in private. So thank you. So next question from Shiraz asks, I want to know if someone can file the I-129F after filing the I-130 petition. Is that good enough to speed up the immigration petition too? Well, here we're assuming you're doing a marriage case with a U.S. citizen, so that's one of the requirements. But will it speed it up, Anya? What's your opinion?
Yes, if we're talking here again after filing I-130, I assume this is K3 I-129F petition. Yes, what we see in our office, we offer this option to our clients, and we've seen the results when some cases get approved. I don't know, 1 month, we have our 130 approved. But some cases, even though we filed it together, nothing changes. So I don't know how they go with it, but yes, it's 50-50. Sometimes it helps, sometimes it doesn't. But again, there is no fee for that for K3 as long as you file with the I-130. And again, very important to note that this option is available only for U.S. citizens. If you're a U.S. citizen and you file for your spouse, yes, this is you can do that. If you're a green card holder filing for your spouse, unfortunately, K3 option is not available for you. Yeah, you can give it a shot. There is no filing fee for I-129F when you file together with an I-130. I'm talking about K3, and see what happens. But again, if USCIS, it's very rare that USCIS approves these K3 petitions. They see it, and most of the cases get the I-130 approved faster. Okay, but there is still a chance that they're gonna approve K3, and if it happens, it's gonna in the long term cost more money and more time dealing with the government, because once case 3 gets approved, a spouse has to go to US embassy to get their K3 visa. They have to come to the United States. They have to apply for adjustment of status after they come to the United States. You have to pay all the fees. You have to do it all, again. And while if your I-130 gets approved, your spouse gets to the embassy. If everything is fine, they get their immigrant visa. They enter the United States, and they're supposed to have their green card within like 1 month after that. So again, this is risk. It depends on what you want. You want your spouse here faster. Okay, this might be applicable. And if you're okay with filing for adjustment in case K3 approved faster. So it's really depend on your personal situation and what do you want, what is more preferable for you.
Yeah, you took the words out of my mouth. It's just be careful what you wish for. If you get the K3, sometimes it's a lot more work and hassle. The next question asks about withholding removal, which we don't typically deal with. But if you're a U.S. citizen, S123 is your name, and your mother entered lawfully, potentially as possible, there's just a lot going on. Because if you've been in removal proceedings, there's just a lot of history to the case to be aware of. So it may be possible, but you should talk with immigration in private on that. Next question is H-1B or O-1 visa better for Indians to file employment-based green card? Are you saying is H-1B and O-1s are work visas? Is that better than filing an employment-based green card? It's not better or worse, they're different things. So H-1B and O-1 are coming to the U.S. temporarily to work. The employment-based green card come permanently here. Now, if you're born in India, it takes forever to get the green card. So typically, you apply for the H-1B first if you have an employer, or O-1, you file that. And you're here in the United States and working while the green card case is pending. So that may be an option, but it's not about being maybe you're asking is H-1B or O-1, which one's better? H-1B is probably better because it's dual intent, but there's a time limitation for that unless you file for adjustment of status and get the AC-21 extension. O-1 visa is a little more flexible, but you might get some immigrant intent issues come back and forth later. Probably not, but it depends on your background. H-1B requires an employer to petition for you, and O-1 does nominally require an employer, but it's based on mostly your extraordinary ability. So, what's your background? Can you justify an O-1 or not? So that comes a factor, an issue too. H-1, O-1, you can always petition for it. H-1B, there's a lottery for most people, so there's a limited time for most people to apply because it's subject to the cap. So there's pros and cons for both of them. It really depends on what you can get. So we just do that and take forward. But thanks for your question.
All right. Next question we have from Noof. I'm the visitor visa, and I'm here with my daughters in college, but I have to leave the country in 5 days.
Okay, I don't see the rest of the question up there. You can always try requesting an extension of your tourist visa. They should have done sooner with 5 days left. You might be in trouble, but you got to file an extension if your point is that you want to stay here a little bit longer. Yeah, and in this urgent cases, the best way is to file extension online because it's gonna get you a receipt immediately. And if you're filing for extension B1, B2 tourist visa extension, you have to file while you're still in status, while your I-94 is still valid. This is crucial for this type of cases. Definitely. Now, next question asks about being flagged at the airport. It is what it is. You might have some history. You should talk with the immigration attorney in private. But if they allowed you back in, it's not an issue. If you had hassle at the airport, so it's really case specific, but usually it doesn't make a difference. And next question after that are predictions about the visa bulletin. We don't have any. Mahesh says hi. Ginger asks, which state are you in? Can you please send me your information? I have a case for you to do. Well, I'm in California. Anya's in Virginia, but we handle cases from across the country, the cases we handle. What you got to do if you want to schedule a consultation is email us info@jqklaw.com and briefly explain the immigration issue that you have. Or if you want to talk to Anya, Anna, ANNA, @jqlaw.com, and let us know what kind of case it is, see if something we handle, and then we can schedule a private consultation about it. Okay, Jack is asking, what about C1 transit visa if I apply for paperwork or marriage with someone who had citizenship? Well, I know this is problematic, right? Because I would give it to you to answer, John. Yeah, the C1 visa is a transit visa, typically for people who work on boats or ships or something like that, but it's other transit. You're typically not allowed to file for adjustment of status with the C1. So it's a crew member kind of visa for if you're on a boat or something like that. So you have to go the consular processing route. There are some rare exceptions where someone comes in on a C1 not to do like for crew member stuff. But overall, you got to talk to the attorney in private, but you can file for a green card. You probably will need to do consular processing. So you got to go through the I-130 process. They mentioned you go to the interview. That's most likely going to be the appropriate way to handle that. And if you want, Katrina, my wonderful assistant, named you as a winner of our free consultation raffle. We got one more, I think, after this. We've had 4 so far, maybe 5. I'm not sure. But just take a screenshot where you're watching this so we can see your username, and then email it to me at info@jqklaw.com, and we can talk in private about it. A quick note, Mahesh on LinkedIn keeps asking where do I post a question? The same place you posted that question, so you're right there. Anil asks, Anil, why don't you go ahead?
Okay, so Anil asks, my RFE was received by USCIS and case status said correspondence was received for my I-485. What's the next step? Well, they have to review it. You have to give them some time to review it. Again, it depends on like what kind of RFE was it? Was it the request for evidence for your medical exam? And what we see recently, if we get this kind of request for evidence and it's marriage case, they once they get the medical exam and they decide to waive the interview in your case, usually your case getting approved if everything else is okay within like a couple of weeks. So, but now during holiday season, probably it's going to take more time. But if it was received, they work on it. So you should hear decisions. Sometimes it takes them more time. Sometimes it takes them less time. But hopefully you got to get it resolved soon.
Definitely. Next question, they've asked, how rare is it for a CR1 visa to be denied? Is it common? It's not common, but they do get denied. It just, it's not a good way to look at it for your own case. You just got to have a strong case for yourself. Parent Andrew on regular says, what's a fake green card? So I'm just, making up a fake green card, printing it out. And Yasmin asks, what does it mean if it says your case hasn't transferred to another office? It just means they transfer from one USCIS office to another for someone else to review it. That's all it means.
Yeah, sometimes they do it. They do it for to speed up the adjudication, and if your office is too busy, they can transfer it to other office that is not so busy, just to get it out faster. So most likely it's a good thing.
Yeah. Now, Shay asks, please explain in detail the NVC process. It's not realistic for us to do that here, but if you look up YouTube and type in JQK Law Consular Processing, I have a 20 or 30-minute video where in detail I break down every part of it. And if you download the Ultimate Marriage Green Card Guide, marriageimmigrationlaw.com, that's www.marriageimmigrationlaw.com. There's a chapter that goes over it with the link to that video. And I've had people say they've used the book to take care of their own case. I can't recommend that. You should have a lawyer. But if you want in detail, it's not realistic to ask here. Go check out that great video I put out. It's one of the best out there. It really talks about everything.
All right, ladies, princess. Can someone with a tourist visa file adjustment of status waiting for interview date? Okay, so my understanding is that you have probably I-130 pending for consular processing, right? And you want to file for tourist visa to come to the United States. Well, again, we get this question very often, and the general answer that we give, you can give it a shot, you can try, okay? But again, you have to be truthful, you have to disclose that you have a pending petition with the USCIS, again, and tell them you have relatives in the United States, tell them that you have a pending petition. All these questions are asked on DS-160. This is non-immigrant visa application, so you will all find it there, and try your best. We have cases where people got approved in this same situation, but again, it's up to the consular officer. It's up as long as you are truthful. Even if you get denied, it's not going to affect your I-130 consular processing case.
Let's say they already had a tourist visa at entry, that could be problematic because they'll say have a case, but if they let you in, you just can't come in with the intent to adjust status. That's your intent, that's fraud. But if you come and change your mind, that may be okay. It's a case by case decision. We need more facts about the case. So, just be careful. That's all we can say there. Now, the one note is we're going to run out of time in a few minutes, so we'll try to get a couple more. I know we have like 20 more questions left. Sorry about that, but thanks for.
Yeah. Come next time. Come next week. I'm not going to be here, but John will be here answering your questions live. So every Tuesday, 5 p.m. Pacific time.
Definitely. So John says, I'm a green card holder. Filed I-130 for my spouse in October overseas. What should I expect interview my wife? There's no expectation when it'll happen. It depends on what country they're from, how backed up things are. I don't know what country they're in. I don't have an answer to that, unfortunately. Expect a wait. That's the best I can say. Can someone with an expired visitor visa get married? Getting married in the United States is not based on your immigration status, so you could get married. But whether the next steps of getting a green card, that's a whole thing that you need to know a lot of facts about your case. I do want to mention, Katrina says Jack is a raffle winner. I don't remember who Jack was, but hey, Jack, if you're still watching, take a screenshot where you're watching this so I can see your username there. I know it's you, and email it to me at info@jqqlaw.com, and we can schedule a private chat. Let's do 2 more questions and call it a night. I'm getting kind of dizzy from answering all these questions. So let's see. What are the next 2 questions? Oh, well, this is not a question. Merry Christmas to you. One of regular says, Attorney Kostradi, pretty attorney. I love the festive colors. Thank you so much. See you. Good to see you again.
Yes. Thank you, guys. We were thinking how we shall dress up, for this live, because it's like kind of special Christmas, New Year / edition, and Happy New Year to everyone watching us today. Thank you so much that you guys been here, and we have a lot of people who watching us watching John every single week. Really appreciate that too, and we wish you all the best in 2023, and I hope all your immigration issues will get resolved, and you will get closer to your end goal of getting this green card. So good luck to everyone, and again, thank you so much for being with us this year.
Definitely, yeah. Thanks so much for tuning in. A special 1-hour episode. Unfortunately, I think we'll just have to call it a day because the show is ending. It's almost an hour. But if you want to schedule a private consultation, all you got to do is email one of us, either Anna at ANNA@jqqlaw.com, myself, John, at info@jqqlaw.com. Emails are on the screen. And schedule a private consultation. There are fees for private consultations, but just email us with your issue. See if it's even something we handle and we can take care of for you, and we'll take it from there. Having said that, like and subscribe. If you're watching this, leave a good review. It helps us out. But I won't take it any longer. God bless everyone. Have a good New Year's, and we'll see you in 2023. Bye, everyone.
Happy holidays.